to you over the next couple of days. Yes, welcome. First and foremost, I trust that Zukiswa shared the slides with you guys so long in terms of ethics and CLP. I've made a couple of adjustments to the ethics slides. I'll share those with Zukiswa so that she can just forward them on to you. I'll also indicate to you where I've made those changes. That is what we will mostly be working on for the next 2 days on ethics, and then for the CLP slides as well. In relation to the ethics slides, as I've mentioned, there's a couple of changes that I'll make you aware of, and I'll be moving between the slides and the actual guide itself. So in terms of legal ethics, I'll be following the guide quite closely. So you can have your guide next to you or open on your PC if you've got an electronic copy as well, because we will be working with that. For CLP, I'm not going to work too closely in terms of the structure of the guide. I'll indicate to you where I'll be following the guide closely or refer to specific pages of the guide. There is certain general concepts that the CLP guide refers to, such as separation of the powers, basic principle of democracy that I take it that you've covered in human rights as well as constitutional law as undergraduates. I won't be repeating that. And yes, so I hope that you enjoy the next few evenings with me. Just a bit of background. I'm teaching here at the Nelson Mandela University here in the Eastern Cape. And I don't know what the weather is in Gauteng at the moment, but it is absolutely miserable here. Strong winds and rain and very, very cold. So I think the cold front should be hitting Gauteng in the next couple of days. I'm currently teaching admin law as well as public international law and introduction to law. I used to teach at UNISA for many years as well, where I taught fundamental rights and some of the human rights master's courses as well. And prior to that, I practiced as an attorney at the Legal Resources Centre, the Joburg office in their constitutional litigation unit. So that is just some background about me. Some housekeeping before we start. So obviously we start at 7:30 sharp each day. I just want to get a feel for the group. Do you want a longish break or sort of a supper break in between, or can we carry on with maybe just one or two short leg stretches and just water breaks in between and comfort breaks, and then we just carry on? And if we finish a bit earlier in the evening, then we finish earlier. Or would you like a substantial break in between? I'm not sure exactly what the schedule is in terms of the breaks. So please indicate your preferences. I see a couple coming through. That short break should be fine. And then if we finish earlier for the shorter breaks, then we finish earlier. When we're done with our work for the evening, we're done. And we call it a night, whether it's before the time finishes or not. Is everybody fine with shorter breaks throughout? Do we have consensus? All right, perfect. I see there's just one hand at this stage. Please ask your question. You're welcome to unmute your mic. I see it's Janae, Sunisha. Do you have a question? Just please unmute your mic if you've got a question. Sunisha. And there's one from Anri Labuskachni as well. Anri, you can unmute your mic.
Hi there, can you hear me?
Yes, I can. Now I can hear you.
How are you doing?
Well, and yourself?
I'm good, thanks. I just wanted to know that some of us aren't added onto the group on the eLeader platform as of yet, and we have sent emails. So is there anything that you can do in this regard, or should we just remind the other lecturers or people that are in charge of the course just to add us? Would that be fine?
Yes.
Or...
please send your queries in that regard to the administrator. That would be Sukiswa. If you want to, you can copy me in on the mail as well. But yes, just please send that mail on to Zukiswa.
Okay.
I'm sure that
Perfect.
she'll be adding you. That she'll be adding you shortly. Just
Okay.
another housekeeping.
Thank you.
No, absolute pleasure. Just another housekeeping rule as well. So when I am busy teaching and I've got my slides on as well as, or I'm sharing, when I'm sharing my screen, I'm not able to see the chats in the chat box. So if you'd like to ask a question whilst I'm busy presenting, obviously just please unmute your mic and ask your question, or I will stop at regular intervals, obviously to allow questions to be asked. And you can also ask your question in the chat, but then I will only be able to get to it once I stop sharing my screen, if that's in order. Just before we start, there's another question from Nomfundo. Nomfundo, you can unmute your mic.
Kali.
How are you?
I'm good, thanks. How are you?
Can't complain. Your question?
Not a question per se, but in preps, I noticed that my hard copy training guide is missing pages 25 to 28. So I just wanted to raise it. I'm not sure if I'm the only one, but I'm not sure how important those pages are. I don't have digital copies, I only have hard copies. So it does not have pages 25 to 28.
That's fine. We could also follow up with the administrator, but I can quickly just, whilst I've got you on the line, just check if I've got a page 25 to 28. I don't follow, I mean, the guide word for word, if you're concerned about that. I do see I've got a page 25 to 28. So maybe you should just request those relevant pages from the relevant administrator. I think I do specifically make reference to some of those pages. So I think it might just be a good idea to alert your the administrator to the fact that you're missing those pages so that they can make a plan to get those pages to you as soon as they're able to.
All right, thank you so much.
Okay, perfect. If there's no further questions, I'm just going to stop sharing my camera, if that's in order with everybody. And then shortly we will actually start with the lectures. And as I have mentioned, so I won't be able to see my chat. If you'd like me to stop or explain anything in a bit more detail, or if you've got a pressing question, please feel free to unmute your mic and just raise your question with me. I do tend to go very fast, so also please feel free to interject when you feel that I'm gaining speed and that I'm going far too quickly. Charlene Mare, you've got a question?
Good day, Professor Amanda. I just want to find out quickly, what group were you guys referring to now? Is it a WhatsApp group or what group is it?
It might be on the eLeader platform, as I understand. So it must be your access to the eLeader system, if I'm not mistaken. I think that might be the issue.
Okay, thank you. Now I've got that sorted. So thank you very much.
Yes. So any administrative queries you're welcome to raise with Sukiswa in terms of accessing to the eLeader platform, or as we've just discussed in relation to missing pages or not having the guide, etc. Please contact the lead administrator Sukiswa in relation to that. All right. If everybody's all right, and if there's no further questions, I am going to proceed to share my screen. And as I've mentioned, I'll be following the guide. I'll not be following the guide word for word. We will be covering the main aspects of ethics. I also trust that that there is a great portion of it that would be for self-study and for you. There's a lot of examples that the guide do refer to. So in your own time, you're more than welcome to go and read through those examples just as being illustrative of the points that we will be discussing during the course of the next 2 or 4 evenings, actually, but especially in relation to ethics. Please take the time to go and read through those examples that's provided for you in your guide, which is quite detailed, but we will be following the sequence of the guide so you can have it next to you, open next to you, as we work through the relevant guide. Here and there, you'll see in the slide, I just make reference to some extra sources or resources as well that you're more than welcome to go and study in your own time as well. So there we go. I'll be sharing my screen. I trust that it is visible to everybody at the moment. If not, please let me know. And as I've mentioned, any questions or queries throughout, just unmute your mic and just ask your question. That's better. All right. So first and foremost, we start with what is professional legal ethics? Now, professional legal ethics is the rules of conduct that regulates the attorney's profession. The big question mostly that legal ethics is concerned of is, are you a fit and proper person to practice law? The narrow interpretation of that can be found obviously in the professional regulations, as in terms of the Act, the Act itself and the regulations that's also published in the Act in terms of what is necessary of a person to be regarded as fit and proper, and then also a more broader interpretation, which is right and honorable conduct. You can almost say that ethics is almost that moral compass that people have and should have in relation to doing the right thing. So the public is entitled to a fairly administered judicial system with legal practitioners that act responsibly and ethically in the public interest, and that they will not abuse the law for the benefit of their clients, obviously, and obviously to their own benefit as well. You must not take advantage of the opponents or of the public's purse. So that isn't just what ethical conduct is. We all know how the legal profession is sometimes viewed. We're all viewed as a bunch of sharks just out there to grab people's money. And the purpose of legal ethics is to prevent that, and also to see that we all operate in terms of stringent ethical rules. So the reason for that is, and why we study legal ethics specifically, is to understand the ethical standards applicable to the legal profession. Very important is to develop moral reasoning skills, to develop moral autonomy and moral decision making. And as I've mentioned, that is more in the broad sense as well, the broad sense or the broad understanding of legal ethics or ethics in general. Develop ethical awareness and ethical consciousness, both personally and professionally. All right. And key, as I've mentioned, and especially to young attorneys and to young advocates who want to be admitted to the legal profession, is the question whether you are fit and proper to practice. So you will be admitted to the legal profession if you are a fit and proper person. Here, it is important to note that the burden of proof is on the applicant here. So when you apply for admission to be admitted as an attorney, the burden of proof is on you to prove that you are fit and proper. And it's basically character screening. It is not a specifically defined term, and generally you must show integrity, reliability, and that you are honest. Although the burden of proof is on the applicant to prove that they are a fit and proper person, the decision remains ultimately with the court, so it is a discretionary decision. So it's within the discretion of the court when they receive your admission papers to decide whether you are fit and proper to be admitted to the attorney's profession. Now, if you have a look at your guide, you'll see examples of fit and proper on page 4 of the guide. We can just quickly move to the guide and just have a look, just as illustrative of those examples, which I've mentioned before as well, in relation to what you can read through in your own time. All right. So here is examples of the interpretation of legal ethics and what it means to be a fit and proper individual. So these examples are illustrative of what you can read through in terms of self-study. Right, if you're not a fit and proper person, you won't be admitted, or if you are already admitted and you are not fit and proper, or it seems during your practice that you've lost your ethical compass, you can be struck from the role. Examples of not being regarded as a fit and proper person is if you've got a previous criminal conviction, if you solicit for work, also the paying of kickbacks. That happens a lot within the attorney's profession, especially in conveyancing, etc. When you collude with estate agents or even with the banks in terms of you refer clients to us, then we'll be paying you a certain rebate. Most unethical conduct in the attorney's profession relates to the misappropriation of trust money and a lack of proper bookkeeping. So we'll be focusing quite a bit on it during the next couple of days, or the next 2 days is the focus on trust monies and and the importance of proper bookkeeping. Very important in relation to an attorney is to not assist a client to break the law, and also do not advise a client how to do so. And being fit and proper does not only relate to your professional life, but it also stretches to your personal life, as your personal actions might bring the profession into disrepute, and it also might be considered when if an application is brought to strike you off the roll. So obviously, whatever you do in your personal life should also be above board, because it can have an influence on being regarded as a fit and proper person. Now, the sources of legal ethics. So where do we find these? Very important is the Code of Conduct that is published by the South African Legal Practice Council, or the LPC, which is effective from the 29th of March 2019. A very good idea for any young attorney is to have a copy of that Code of Conduct, and obviously a copy of the Legal Practice Act as well, as it's amended, which came into effect on the 30th of October. It repealed the old Attorneys Act, and it also replaced the different provincial law societies that we had. And now we've got unified regulations for the profession, obviously over the overarching board of the Legal Practice Council. Also specifically relevant is Chapter 4 of the Legal Practice Act, and specifically sections 36 to 44 that regulates professional conduct and the establishment of the relevant disciplinary bodies. The Law Society of South Africa represents the attorney's profession. It brings together the Black Lawyers Association and the National Association of Democratic Lawyers and Independent Attorneys. You're more than welcome to have a look there on page 20 of your guide. It talks a bit about the LLSA, who it consists of, and we know that this is also the platform for LEAD, and it provides, as you are busy with at the moment, the practical training to CAs. You'll find their website, and a lot of their website is also full of useful information, especially in relation to admissions, etc., that you can that guides attorneys and young attorneys, and also when you are admitted in terms of maybe going for an extra course, sharpening your skills, specializing in a specific area. I can just hear somebody's mic is unmuted. If you don't mind, just checking everybody that their mics are muted, please. Let's just see if we can maybe see the person whose mic's unmuted and then muted I can mute it from my side if I need to. Yes, that's just one of the niggles of online teaching. So please just make sure that when you join, that you make sure that your mic is on mute. All right. The Legal Practice Council rules is also relevant, made in terms of section 95(1)(b) of the Legal Practice Act. Also very important, and we will be having a look at a specific court decision tonight in relation to admission, is precedent. When we mentioned being regarded as a fit and proper person, we said it's a discretionary decision by our courts. So obviously, guidance by our courts are very important in this regard. And also, if you've got any pressing questions in relation to you know, will I be admitted if this is the case or that is the case, the best place to go to go look for guidance is in our precedent. And then obviously, this is supplemented by the common law and then by our secondary sources as well, academic writing, textbooks, and foreign influences. But obviously the most important primary sources of legal ethics, especially in relation to admission for young attorneys, is the relevant act, the relevant code of conduct, and then as well court precedent in that regard. So that is the sources of legal ethics. And it is a very good idea to have yourself a copy of the Legal Practice Act as well as a copy of the Code of Conduct that is published by the Legal Practice Council. All right, let's maybe have a look a bit closer at the LPA. So the LPA regulates the admission and the enrollment of legal practitioners. It regulates professional conduct. Very important, it establishes the Fidelity Fund, which we will be going in a bit of detail tomorrow, and a board to control the fund. We'll have a look quickly on page 24 of your guide in this regard. So just please excuse me whilst I'm just moved to the relevant page. It's just easier to, when I refer to the guide, to actually open it up so that you can see where I am in the guide at the moment. All right. So in terms of the Fidelity Fund and the important implications of the Legal Practice Act and the LPC, you're more than welcome to have a look here at page 24. The importance of what that Legal Practice Council does, as well as the Act, and the reference there to the Fidelity Fund. The LPA provides for 9 provincial councils with delegated functions each. A very important change brought about by the Legal Practice Act, which you might know about by now, is as well as that advocates can now also accept briefs directly from the public, but they must have trust accounts subject to the rules and regulations of the LPC. So we know that in terms of the old Act, there was a strict division between attorneys and advocates, that attorneys cannot receive instructions, advocates could not receive instructions direct from the public, but that now has changed. And important there is the table that you have on page 26 of your guides, and that is why the one student mentioned that she doesn't have page 26, so it might just be a good idea to just contact Zukiswa to get the relevant pages, because it gives this nice block that sets out the difference between an attorney, a trust account advocate, and a referral advocate. Now, under the old under the old Attorneys Act, we only had provision for attorneys and referral advocates. So there wasn't something like a trust account advocate. Now we've got a trust account advocate. So let's just stop a bit at this at this table that we've got here, just to have a look at what the difference is and what is now allowed for in terms of the Legal Practice Act. So attorneys are admitted by the High Court. They're enrolled by the LPC, and they can also be conveyancers and notaries. Now, trust account advocates also admitted by the High Court, enrolled by the LPC, which is the exact same for referral advocates. In terms of appearance, attorneys have appearance before any court, but a certificate is required. We know if you want to act before the higher courts, the Supreme Court of Appeal and the Constitutional Court. Well, whereas trust advocates and referral advocates all have appearance in all the relevant courts. Attorneys are briefed by the public, and they must have a trust account and a fidelity fund certificate and comply with Chapter 7 of the Act. Now, trust account advocates are also briefed by the public and justice centres, and they must have a trust account and a fidelity fund certificate and also comply with Chapter 7. So if you are an advocate and you would like to receive, if you want to be admitted as an advocate and you would like to receive briefs directly to the public, same as an attorney now, you have to have a trust account and a fidelity fund certificate. The reasoning for allowing trust account advocates is to make legal costs, or to provide for access to justice to a greater audience, because of the fact that lawyers are so expensive and advocates are so expensive. There is a possibility to cut out an attorney and to just make use of a relevant advocate. But obviously, if you wish to do so, that relevant advocate needs to, same as an attorney, have a trust account and a fidelity fund certificate. Now, a referral advocate is briefed by attorneys and justice centres. In terms of practice, very similar: own account and a juristic entity with other attorneys, law clinics, the LASA, also with state attorneys and certain Chapter 9 institutions. Trust account advocate, also own account, may not share fee, law clinics, LSA, state account, and that's the same for referral advocates. So you'll see the main difference there is the fact that attorneys can practice in an entity with other attorneys as well. So,
sorry, Prof.
Yes.
Yeah, I just want to ask, in terms of the referral, you say that a trust account advocate can only receive referrals from justice centers and the public as well. So are you saying that attorneys are not allowed to brief a trust fund advocate?
No, an attorney can brief a trust account advocate if if that's how. But the purpose of a trust account advocate is to cut out the attorney. So if you really want to, you can still get briefs, but that would sort of defeat the purpose of being a trust account advocate, because you are able to get a brief directly from the public. So you don't have to go through, and obviously if that is the relevant case, you have to disclose the fact to, this has to be disclosed to the relevant referring attorney as well, to the fact that you are a trust account advocate, because otherwise you would be billing your client twice, whereas, as an advocate and for the attorney, whereas because you can be briefed by the public, directly by the public, it cuts out the attorney. So I don't see any reason why you can't, but that should be disclosed, and it would defeat the purpose of being a trust account advocate, to still accept briefs from relevant attorneys. And remember, the main purpose of a trust account advocate is to provide access to justice to those who are not able to afford high legal fees.
All right, no, thank you, Prof.
Sorry, Prof.
Yes.
I see there's a number of hands raised in the lobby. I don't know if you want to take their hands. Taryn, Mangobe, and Marco.
Okay, I'm gonna move to the lobby, and I'll move to the chat section as well. Thank you for alerting me to that, and let's just go and to those questions. I'm going to start with the first one. Mankope, you can ask your question.
Thanks. Hi, Prof. Good evening, class. I just wanted to ask around may not share fees. I think you briefly spoke about it, and I stand to be corrected, where the reason we're not sharing fees is because we're cutting out the attorney briefing, either a trust advocate or an advocate, period, in this particular case. But I just would like you to explain that may not share fees aspect between the three. I just didn't quite get that.
Thank you. In relation to may not share fees, so obviously if you practice as an advocate, you're not able to share the relevant, I mean, you bill for your own account. That is what it refers to. So when you see this, I hope that you can still see my screen on this side. So when it refers to may not share fees, it refers to the fact it's almost like paying a kickback. So you're not allowed to share the relevant fees. You bill for your own account, because otherwise we're able to collude our fees to say, oh, I'll give you this client and we'll share part of the fees. So you bill for your own account, if that makes sense.
Okay, no, that makes sense. Thank you.
All right. I'm just quickly going back to the hands again, if that's in order with everybody. There we go. Bella, you've got a question?
Good evening, Prof.
Good evening.
I just want to ask a question with regards to appearance by attorneys.
Yes.
It says any court, but certificate is required. Okay, what is the process of obtaining certificate, and are there instances that one may not get the certificate to appear in High Court and Supreme Court of Appeal, and yeah, Higher Court?
Thank you. I'm not exactly sure as to the process, but it is set out in the relevant act. So you just merely make, you follow the steps that's set out in the legislation.
Okay.
You apply for the relevant certificate. So obviously, again, are you a fit and proper person? If you're, it's simply a question of complying with the relevant criteria that's set out in the legislation, and then that relevant certificate should be granted. So what one should be aware of is the fact that you don't get a matic right of appearance, such as trust account advocates and referral advocates in relation to appearing before the higher courts. If you are an attorney and you would like a certificate of appearance, it just means that you've got to follow those extra steps once you are admitted as an attorney. Follow the extra steps that's set out in the relevant legislation and its application, and it would be granted to you. And obviously, the general rule in terms of admission first has to be complied with is, are you a fit and proper person? So it is, if you would like to apply for appearance in the higher courts, it's simply as following out the steps that's set out in the relevant legislation, lodging that application and obtaining the relevant certificate, and then you've got right of appearance in the higher courts.
Thank you.
All right.
Sorry, is the right of appearance on a case-by-case basis, or if you get a certificate to appear in the High Court, then it's for any case that you want to appear on
Yes.
in the High Court?
If you get the certificate, it's for any case that you'd like to appear in. Obviously, if you feel that you are able to present your client to the best of your ability and that you've got the necessary expertise to do so, then you can. If you've got the certificate, then you've got right of appearance and right of appearance in general.
Thank you.
It's a pleasure. Maluleke, yes, Charlie Maluleke, I think.
Hi, Prof.
Charlie?
It's Solofelo.
All
Someone
right, you've
went
got a
before me and you called me. Prof, my question is, how do you go about being a trust account advocate? Is there a particular exam you write? Because I've realized that it's not all advocates that have these trust accounts. It's just a few.
yes. So obviously, you still, if you want to practice as a trust account advocate, you still belong to the bar. You still still do your pupillage, you still write the relevant bar exam, but obviously with the extra hurdles then of obtaining your relevant fidelity fund certificate, etc. Or obviously we do have our independent sidebars as well, but we know that the best port of call would be to belong to a specific bar, as well as doing your pupillage when you get admitted as well.
Thank you.
I'm going to allow one more question before we move on these specific aspects, and we'll also remember that towards the end we will open we'll open the floor as well for questions pertaining to admission, etc. Huiti, if I'm pronouncing the surname correct, you've got a question?
Good evening, Prof.
Yes.
In terms of appearance in court, I saw that in this course that we are currently doing, there is trial advocacy. And it is stated that you get a certificate in order to appear in court. So is it that the same thing that one of the classmates asked about? Isn't that the certificate that you get in order to appear in court? Or do you still need to get another one on top of the one that we're going to be doing in this course?
I think the trial advocacy course in lead, I don't think that is the specific, I don't know if they do the application for you, but I don't think that is in referral to the right of appearance certificate. So I'm not sure if the LSSA provides that service, but as I understand, that would be a separate application that you lodge in terms of obtaining the certificate for appearance in the higher courts. And that you'll only be able to get once you are admitted as an attorney.
Oh, okay. All right. Thank you,
Right.
Prof.
So the certificate for trial advocacy here, I think, is something different that they refer to. Remember that you'll only be able to obtain that certificate of right of appearance in the higher courts once you're admitted as an attorney. All right. So
Right. Thank you, Prof.
It's a pleasure. So just please have a look at the different legal practitioners that's provided for in your guide, and just take note the difference between this and what the previous Attorneys Act provided for in that regard. I'm moving again to my slides. All right, so now we're going to have a look at the requirements in relation to be admitted as an attorney, which I think is very pressing for each and every one of you sitting in this class. I think the purpose of all of this is to be admitted as a legal professional. So first and foremost, it is a LLB degree or a BProc degree. Before we had the overarching LLB, attending the practical vocational training, as you are busy doing now. The relevant courses, attending practical vocational training is obviously your articles of clerkship. Then also writing the admission exam. Remember the legal practice structures that we just went through now. We follow the English system of a divided bar, where we had the attorneys receiving the instructions and then briefing counsel. So we've got attorneys and advocates. But remember now we've got trust account advocates as well. Attorneys, in addition, can be admitted as notaries and conveyancers, as well as attorneys can practice on their own or in a partnership with an attorney's firm. The general requirements of entering such a partnership, instead of just practicing on your own, is set out on page 31 of the guide. then the LPA also provides for legal practices such as law clinics, subject to approval obviously by the LPC, and if the relevant requirements are met there as well. So you can do your article of clerkships at a relevant law clinic. Many of the universities do have these law clinics, so you can serve your articles of clerkship as there as well, and it will count as your relevant practical vocational training. So I just put some references down here in relation to getting admitted, which I found quite useful sources. And we can just quickly move to these and just have a general look in relation to the requirements for being admitted. All right, so this is the one site that I found very helpful in relation to if you're in the process of drafting your relevant application to be admitted as an attorney. There's templates here that you can download, and the reason why I do like this site quite a bit, or the references that they do provide, is they take you rule by rule through what you're supposed to be providing in terms of your admission papers. So confirmation of the jurisdiction of the court, full names, confirmation of South African citizenship. So this takes you through exactly what the requirements of the Act is. Very important in relation to admission papers is, well, I know I did it, and I know most of journalists, we always get, the person who was admitted before you in that specific firm, or a friend that's recently been admitted. We always get their papers to say, to sort of work from that as a basis. But very important in relation to that is just, you can use it obviously as an example, but to make sure that you not only just copy and paste an admission application, but that you personalize it and that you put your own personalized details, etc., in that relevant application. And very, very important is to make sure that you comply with each of the rules that's set out in the relevant Act. And that is why I referred you to this site, because it provides you with these very handy pointers in terms of exactly what is needed, rule for rule, in relation to your admission application. Obviously, very important that we've discussed is declaration about fitness and properness. And we can just stand still at this as well. As part of your founding affidavit, you must declare that you are a fit and proper person for admission as an attorney or legal practitioner, and this will include confirmation that the applicant has not previously been admitted as an advocate or attorney of any court and have not made an application for such admission, confirmation of no previous criminal conviction and no criminal investigations pending, confirmation of no previous civil judgments and no civil proceedings pending, confirmation of no previous disciplinary actions by the law society, university, or previous employer, if applicable, and no disciplinary actions that's currently pending. The fact should be fully disclosed to the court, very important. If there are any of the above allegations against the applicant, previously or pending, and that's where we're going to have a look at a court judgment there. So that is a very important point. Confirmation that the applicant's estate has not been sequestrated and that there is no application for sequestration pending. Confirmation that the prescribed notice was given to the Legal Practice Council and that the prescribed fee has been paid. So fitness and properness is about declaring what is relevant to the court in that regard, and there you get a good summary of what is needed in that regard.
Sorry,
So
Professor.
Yes, you're welcome to interject.
Hi, thanks, Professor. Good evening. I just want to ask a question relating to the admission, and once you finish the course that we're currently busy with, and we write our exams, and then after this, we will then do our last 4 subjects through the Law Society. Now, once you finish that, and you've passed the 4 subjects that you will have to write most probably next year, and you do not do your articles immediately, and you do your articles, say, for example, 2 or 3 years later, after you've written all these exams and you got your certificate of competence, will the courts penalize you because there is something in the act that says it must be uninterrupted? If you can just shed more light on that, can I do my articles 3 or 4 years after I pass all of these exams that I'm currently writing? Thanks.
That is a very good question, and I'm not exactly sure, but that's what I think you've just touched on it yourself as well, is that there is a specific. I think there is a specific reference to time prescription there as well. So my best advice in that regard is please go study the Legal Practice Act very closely in terms of the relevant time prescriptions that's provided, because it also not only works in in the fact that there's a break in terms of doing this and then going ahead and doing your actual articles of clerkship as well. But a lot of the times as well, what happens is you do your articles of clerkship, but then you don't apply directly for admission, or you don't do the coursework immediately as well, and there's a long period of time. So obviously, a short period of time should not be a problem, and I think the period of time is specifically prescribed by the Act. So please just go have a good read of the relevant Act and the relevant times that's prescribed. But yes, because what the court can do then is it can require you to redo the courses, because as we know, the law is constantly changing. Our legislation is constantly changing. So if there is a big gap in that period, the court might instruct you to go and redo the relevant course of that in that relevant case, or if you and the same goes for serving your articles of clerkship. So I don't think that it needs to necessarily be immediate, but I think there is a specific time limit that's prescribed, but so you just need to make exactly sure that you keep to that relevant time limit, because of the fact that the content of these courses, etc., is constantly changing, and that is something that the court would consider in admitting you as an attorney.
Prof?
Yes.
Just a question with regards to admission. My understanding was that in the past, especially with this vocational training, you would serve your articles for 2 years, and then you would go write your boards and then get your admission. But now I saw someone in our group had written that she served articles for 5 years before the Legal Practice Act came into play, and it was said that she needs to attend this course in order to get her admission. Is that how it is now? Even if you serve your articles for 2 years, you still have to do this vocational training?
All right. The vocational training is actually in reference to the article of clerkships, but you are prescribed to do this training, either the 6 months training or the shorter training, which is if you don't do the full 6 months, obviously, of like you are doing now at the moment, which also then would only require you to not do the prescribed 2 years, but only then 1 year of article clerkship, obviously together with this relevant course. Is you get different options in terms of the Act. The 5 years usually is in reference to the fact where students they are still busy with their LLB degree. So then they would do, then they used to do a 5 years of articles of clerkship, and obviously they would study then after hours their LLB degrees. So, and then once they have finished the 5 years of article of clerkship and then obviously gotten that relevant degree, they still need to complete the relevant course. If not the 6 months, the full 6 months, obviously there are, if you've already completed your articles of, or you're busy with your article of clerkships and you're not going to do the 6 months, then you do the shorter course, which is the 5-week course. It's usually broken up in two. You get a 2-week course and then a 3-week course, and together it's a 5-week course that you need to complete and have the certificate of completion as well. You are doing the 6 months course, as I understand, which then obviously would allow you to do your article of clerkships, your vocational training that much quicker. So with the certificate, it would be 1 year, as I understand, in terms of the legislation. But very, very important in terms of admission and all the nitty-gritty in terms of, time periods, etc. That is why I said it's so important to get a copy of the relevant act in relation to and following the act very, very closely in terms of getting admitted, what is the requirements, etc. And hence my reference to this site as well, that gives you some information and gives you steps in terms of following each of those rules and getting your admission papers ready. Sabia, you've got a question?
Yes, good evening, Prof, and good evening, colleagues. Prof, I just want to ask in terms of the confirmation of being convicted or the pending case.
Yes.
If let's give a scenario whereby you've been convicted during the process, while you are busy with maybe your articles or you are busy with law school, do you have to provide or to notify the court, or you because you've already started, what can we do? And the second question is, if let's say you have been convicted and the case has been withdrawn, do you have to produce that document to the court before admission, or what do you do? Thanks a lot.
Yes, that is a very important question, and that's actually what the case law that we're going to focus on is exactly that. But as of yes, so the answer is, if you've been committed during your articles of clerkship or whilst you're busy doing your articles of clerkship or before or whatever the case might be, yes, full disclosure is necessary to the court. As I've mentioned here as well, it says the facts should be fully disclosed to the court if there's any of the above allegations against the applicant previously or pending. So irrespective of what it might be, but we'll have a look at the case law. It's so important to disclose the facts to the court. Otherwise, you would not be regarded as a fit and proper individual. So we'll have a look. We're going to have a short break, and then after the break, we're going to quickly have a look at a specific case law that highlights the importance of being fully open to the court in relation to this information and in relation to be declared a fit and proper person. So any information that you might have in relation to a criminal conviction, if it has been withdrawn or whatever the case might be, that needs to be attached to your application for admission. All right, Matlala, is there a question from you in that regard? I'm just going to move over as well to another source from the LSSA itself as well in relation to admission and becoming a legal practitioner, that you can also more than welcome to use in relation to preparing for your admission. And also very nice here, you'll see a reference to the Legal Practice Act and rules are provided for you there in links. And it provides you also with the relevant requirements there for admission, the minimum qualification and practical vocational training. It's all set out here as well. The regulations, everything is provided for you in links here. So it provides you with a good overview in relation to what is necessary in relation to your application for admission. So I think we will just now stand still here for, if it's all in order with everybody, we can take a quick a 10-minute break or 15-minute break. It's now 25 to, if we can say we're going to be back here at 1840, just to allow for a quick break, if that's fine with everybody, and then we'll just have a quick look at that case law in relation to admission and regard and what it means to be regarded as a fit and proper person. Is it in order with everybody if we have a quick break?
Yes, ma'am.
Okay, so
Yes,
it's
Prof.
1825 now, so let's just be back here at 1840 if that's all in order.
Hi, Sandile. Please switch off your camera. The lecture is about to start.
Hi, yes, guys, I'm back. I see it's 18:41. Sandila, yes, if you can, Sandila Mbele, if you can just switch your camera off. I'll be sharing my screen shortly again.
Sometime. Yeah.
There we-
Awuzilala mfethu.
All right, everybody, I hope that you're able to hear me. I'm going to share my screen. I hope that my screen is visible to everybody. There we go. Can you just maybe give me a thumbs up if you're able to see my screen? Michelle Tolliard, you've got a question quickly. You've got your hand raised.
Hi, good evening. Just with regards to the judgments and things, or what makes you fit and proper, I was wondering if there was case law, or maybe we'll get to it, if it comes to a civil judgment, or one that maybe you got many years ago that has since been rescinded, if that's something that you also need to declare, or if there's case law around that.
I will go follow up for you on civil judgments. I think it might need to be included, but on civil judgments, I will just go make sure, and I'll share the information tomorrow with you. The case that we are going to focus on is a criminal judgment, and I included it because it's very recently decided on the 10th of May of 2023, and I am going to just open the judgment itself, so you'll see the reference there at the bottom of the slides. It's the Vacha case, Vacha versus Johannesburg Society of Advocates. Although it was in relation to the admission of an advocate, obviously the principles in relation to fit and proper would be equally applicable to an attorney. So I would just like to share with the judgment with you, because I thought it was quite telling in relation to what is regarded as a fit and proper person. So in relation to the judgment, I just highlighted some of the important aspects that I focused on. You'll see some of the highlighting skills is not the best in the world. If you'd like me to, I will make the judgment available to Zukiswa as well, and then she can email it to you guys so that you've got a copy just for reference. And if you want my highlights as well, they'll be there on the judgment if I send it to her. So just shortly, Vacha sought to be admitted as a legal practitioner and to be rolled as an advocate. There is a single controversy in terms of the court. The crucial consideration which governs his application is whether the applicant has established that he is a fit and proper person to be admitted to practice. The applicant has previous convictions for theft and for escaping from custody. He was sentenced to 6 lashes for shoplifting in 1989 when he was 16 years old. That is when corporal punishment was still applicable to minors. He was sentenced to 2 years imprisonment for escaping from police custody in 2002 when he was 29 years old. He had participated in a robbery. The robbery charge was not prosecuted, apparently for a lack of evidence. The fact of the commission of the crime or robbery was volunteered by the applicant in an application for a presidential pardon for the crime of escaping from custody to explain why he was initially arrested. The pardon application was an annexure to the initial founding papers. All right. The consequence of this personal history means that the applicant was prima facie unfit to be admitted to practice because obviously he had 2 prior criminal convictions. And now it is incumbent on the applicant to adduce evidence to rebut that inference. So we said at the beginning that it is the duty of the applicant to prove that he or she is a fit and proper person. So I'm just focusing on some of the important highlights of the court. So please excuse me if I do scroll through a lot of the factual circumstances. So he launched his application for admission in 2021. He disclosed the convictions for theft and for escaping from custody. He attached a SAPS clearing certificate reflecting the 2 convictions and the sentences that was opposed. He alleged that they had been expunged, but this was not correct. The theft conviction had indeed been expunged ex lege pursuant to the Criminal Procedure Act because of the elapse of 10 years from the date of the conviction, during which period the applicant had not reoffended. That document was omitted from the admission application papers served on the Johannesburg Society of Advocates. When the deficiency was pointed out by the JSA, the document was then annexed in a supplementary affidavit. So thus on 2 occasions, and this is very important, on 2 occasions under oath, the applicant misrepresented the true position. The misrepresentation was never explained in any of the subsequent affidavits filed. So although he came forth and he disclosed the fact that he had these convictions, he did not tell the whole truth in relation to the expungement. He claims it's been expunged or whatever the case might be, but it seems that that was not indeed the truth. Very important is the fact that the applicant had previous encounters with the courts in relation to the application in terms of his admission. The applicant did not turn up at the hearing and the case was struck off the roll. We'll have a look towards the end of the discussion as well as the importance of being on time. Some hours after the court had risen, he presented himself at the chambers of the Deputy Judge President, saying that he had lost his way in the courthouse. He was informed that he would have to re-enroll the matter, but in any event was advised that the papers in the file were inadequate to deal with the issues which have been mentioned above. He was invited to prepare a supplementary affidavit before enrollment and submit it informally for scrutiny by the Deputy Judge President. To facilitate the preparation of the supplementation of the powers, the court specifically provides directives to the relevant applicant. So obviously, the court here was trying to assist him in relation to what he needed to disclose for his admission application to be successful. He provided an affidavit, but again, it remained deficient. Some of the judgment refers to the specific affidavit. You'll see quite a section of it is dedicated to it in relation to the affidavit that he provided. Again, the court highlighted in both respects, there has been a clear failure to give a full and open account. This failure advertises the applicant's inability to appreciate the sacrosanctity of full and frank disclosure, a critical dimension of an ethical lawyer's character. So, as we can see again, the importance of not withholding information to the court. So although I'll have a look at the relevant fact that the civil judgment has been granted, if it's necessary to include those in your admission papers, my feeling is that you rather include it rather than exclude it because of the fact that we need to disclose any judgments that's been granted against us in relation to being regarded as a fit and proper person. And then it's for the court to make the decision whether you are indeed a fit and proper person. Very important in terms of this judgment, and I think this is key in relation to what it means to be an ethical lawyer and to be a fit and proper person, is here in paragraphs 28 and 29 of the judgment. And it says, the court states here, the myriad pressures of lawyering are not to be regarded lightly. The perpetual exposure to clients in distress is one of the sources of a lawyer succumbing to the temptation to take a shortcut or bend the rules because of the subjective moral conviction that the client deserves to triumph. This misconduct derives not from evil, but from a misplaced instinct to champion one's client. Similarly, financial success in practice is hard won, and in no few examples have lawyers lost their ways while traversing the valley of the shadow of poor cash flow by deluding themselves that a little pragmatism can be justified because it is only temporary. Engaging with clients and opponents in a manner that avoids conflicts of interest requires a keen and meticulous grasp of the role of a lawyer. Being able to withstand forceful personalities who, with either charm or bombast, can overwhelm the timid is a core attribute of the kind of character that a lawyer simply has to have. It is for these reasons that a person, to be fit and proper to bear the burdens of being an officer of the court, must have a strong character and have an instinctive inward and unseen integrity, no less than an outward and visible ostensible honesty. The clearing of the required threshold has not been demonstrated in this case. Expressions of remorse might open the door, but what must be paraded is concrete evidence of self-awareness of the character defect, not merely sincere regret. Carelessness with truth and accuracy about the facts, a lack of full and frank disclosure, and a denial of full responsibility for the deeds do not meet the test of being a fit and proper to don the mantle of a legal practitioner. And obviously, the conclusion in this specific case is that the application for admission cannot succeed. So I think these two paragraphs, paragraphs 28 and paragraphs 29, gives a very good summary of what it is to be regarded as an ethical lawyer. So you cannot only be acting in the best interest of your client to the detriment of another, or putting your client's interest above your relevant ethical responsibilities. That is very important to grasp. You serve as an officer. Remember that when you are a practicing attorney or an advocate, you are an officer of the court, and it's not there to serve only self-interest in that regard. So I think this is a very good summary in relation to what it requires to be an ethical lawyer, and also what it says to us is, so when you do your application for admission as an attorney, to be open and to be frank. Sometimes one might have a transgression in your past. You might have been arrested for drunk driving when you were much younger, or involved in an altercation, and there's an assault charge that's been laid against you, or that you've been convicted on. It is very important to obviously to disclose this to the court, and then it is for the court to make the decision whether you are a fit and proper person. But obviously things are taken into account, for example, the fact that it was done several years ago, for example, when you were very young, whatever the case might be. So these are all considerations that's taken into account. By not disclosing, or by only partly disclosing, or by not stating all the relevant facts, you run the risk, as Mr. Vacha here did, of not being admitted and not being seen as a truthful individual, basically. So it's best to be upfront and disclose all the relevant information to the court, and then it's for the court to make the decision whether you are a fit and proper person. But obviously, by fully disclosing all the relevant information and placing that before the court and having nothing to hide, obviously would be a good indication to the court that you are indeed a fit and proper person. Don't leave things out and think that nobody would ever find out. You'll be surprised. You'll also be surprised that maybe even if you are admitted, that some years down the line, a fellow practicing attorney or advocate gets wind of that, and that you are then later struck of the role because of non-disclosure of those relevant facts. So very important is to disclose all relevant information to the court in relation to your admission to be seen as a fit and proper individual.
Sorry to interject, Prof.
Yes.
In terms of other disciplinary measures taken against you, either at varsity and or at work, what are the bounds? Is there maybe a time lapse for that? Maybe it happened 20 years ago, or do you still have to disclose that?
I don't think there's a time lapse. If we just quickly go back to that, the site that I referred you to, and also this answers the question on the civil judgments as well now that I read it. So it's a confirmation of no previous criminal convictions and no criminal investigations pending, confirmation of no previous civil judgments and no civil proceedings pending. So that answers the question on the civil judgments as well. Confirmation of no previous disciplinary actions by the Law Society, that's the one, university or a previous employer, if applicable, and no disciplinary actions pending. So in relation to the university, etc., if there has been a disciplinary process pending, it would be best to disclose it. Also, it would also be obviously dependent on the relevant factual scenario, exactly what the charges were, or whatever the case might be. But in cases, for example, of possibly cheating on a test, and there was a disciplinary, that sort of information needs to be disclosed. So obviously, in relation to civil judgments as well, if there has been a civil judgment, if there has been if you've complied with the relevant civil judgment or whatever the case might be, all of that just information needs to be shared with the court. So rather provide all relevant information, and obviously you'll provide these as attachments to your relevant application. But it is very important to disclose all of the relevant information to the court, to be open and honest about any previous criminal convictions, about any civil judgments or disciplinary actions, and then let the court decide in relation to being a fit and proper person. Because as the Vacha case just illustrated to us, if you don't do that, the court will look harshly upon it if you don't openly disclose. What's also very telling about Mr. Vacha's case is that the court itself took its time, and it said, listen, your affidavit is not up to scratch. You need to supplement your papers, and this is what we specifically are looking for, A, B, C, and D. And by not doing so, obviously he shot himself in the foot as well, because it looks like there's something that you'd like to hide from the court, and then obviously they would not regard you as being a fit and proper person. So it's all about disclosure of the relevant information rather than not disclosing. Because as I've mentioned, even the fact that, let's say there is something, at a university at some stage, you don't disclose it, and it comes to the fore later when you are already admitted, and you're already practicing, and there might be an opponent somewhere that figured out, and then it discloses or it lays a complaint against you at the Legal Practice Council, then you might be in big trouble. So rather be open and frank about things in your relevant application, than rather having to deal with it much later on in your career, and possibly being scrapped from the role in that regard as well.
Sorry, thank you so much.
Sorry, Professor.
Yes, is there a question?
Yes, yeah. It's more of a statement I want to make, and a lot of people do not know they've got criminal records walking out there. Especially if you've paid them, for example, an admission of fine in terms of Section 57 of the Criminal Procedure Act. And once you pay that admission of guilt fine under Section 57(1) of the CPA, you get recorded as a criminal record because you didn't appear. You do not have to appear in court. You pay that admission of guilt. So in terms of that Act 57(6), you will then have a criminal record where they load that criminal record with the criminal record center, especially during COVID. A lot of people has paid fines. For example, we're not allowed to be in possession of alcohol. So they paid, for example, an admission of fine in terms of that Section 57, which gave them a criminal record. And it's true what you're saying is that we need to declare and we need to be certain of what we've got and what we don't have. And if I can just give some advice, a safe way of doing it is the police. I think you pay like 150 Rand or 300 Rand for a police clearance certificate that you do not have a criminal record. So once you're going to apply to be admitted and it comes out later that you've got an admission of guilt fine against you, then it's not going to look good for you because you didn't declare that to the courts when you applied for admission. So I just want to make that statement. Thanks, Prof.
No, thank you very much for that input, and I'm absolutely in agreement with it, with the comment. So make sure, in relation to having a criminal record or not, and disclosing it up front. For example, COVID is a good example. You know, we all transgressed during COVID. Some of us, unfortunately, got caught and got a criminal record or paid admission fines. But I think, you know, see it from the prospect. If you declare that, and if it is you know, openly available to the court, obviously the courts would also take into account the relevant context, COVID, etc. Or as I've mentioned previously, that you were very young when offence took place, or whatever the case might be. So I don't necessarily think that that would count against you in regard to getting admitted, than leaving it out and rather be seen to be lying to the court, which obviously is with which you run a very great risk of then not being admitted. All right. I see that there's two. Yes.
Yeah, I just wanted to check in terms of disciplinary proceedings emanating from previous employer. Is this employer your PVT contract employer or any other employer that you might have had in the past?
That is a good and relevant question, and I understand it as being any employer. But it does say or previous employer if applicable. So you see, it becomes a bit of a difficult question and a bit of a gray area. For example, if your previous employer were a bank, for example, and if you had a disciplinary that was instituted against you because in relation to banks, you work with money, etc. So, you know, as an attorney, you work with trust accounts, etc. So it depends. My personal feeling is include the relevant information, and if it's not regarded as important, obviously the court would not regard it as important, but let the court make that relevant decision. So very important, obviously, is the universities as well in that regard. And I would rather include that not include, and that there's obviously no current disciplinary actions pending against you. So it would also depend on the relevant context of it and the relevant factual scenario. But my gut feeling in relation to that is to rather include than exclude the relevant information. I see two hands still up. Karabo.
Yes, thanks, Professor.
Yes.
I wanted to ask, in terms of expungement, and I'm referring to the voucher case, he thought that his criminal case or record was expunged many years ago, but this was not the case. Now, I'm asking on the basis of the fact that they're saying this was not the case. Had it been expunged, was he supposed to disclose it? One, that's the first question. That if the matter has been expunged, do you still have, would he have been, treated differently, or would his admission be treated differently? Number two is, in terms of fit and proper, from a banking point of view or from a financial institution point of view, they look at the Phase Act. Now, I'd like to know what the courts use to determine fit and proper. Is it a different, is it just the legal, would it be the act from a legal point of view, or do they also use, the financial institution, which is FACE process? Thank you, Prof.
All right, thank you. It would not be necessarily with reference to the requirements that FASE sets out. When you work in a bank, there's specific processes and procedures that you also need to comply with in relation to FASE that I'm aware of. So it's not those specific prescripts, but it is more in relation to disclosing if you have got any, any disciplinaries or any questionable conduct in relation to employer that they should be aware about. Fit and proper, as we said in the beginning, there's no specific definition that's attached to it. So it's absolutely within the discretion of the court to decide whether you are fit and proper. In relation to the expungement of the specific case of the Bacha case that we've read, there's much more detail that's provided in the person's relevant affidavit, etc. But I think the most important aspect that one should carry from the Bacha case is that Mr. Bacha wasn't quite honest with the court. So he was made aware of the fact that this is not exactly the case, but he still failed to completely disclose in the relevant affidavits, and by consistently doing that and not adhering to the court's advice, it could be seen that he was not fit and proper. Khotso, can you just please maybe mute your mic?
Sorry, Prof, I didn't get what you heard because of that interruption. Apologies.
Yes. So I said in relation to what we can take from the Bacha case is the fact that he was not open to the court, and despite the court providing him exact directions in terms of what was needed in terms of his supplementary affidavit, he still did not comply with it. So if his criminal record was expunged, that is still information that needs to be declared to the relevant court. To be seen to be a fit and proper person is to be seen to be honest and trustworthy, if I can put it like that. Remember, we referred to a narrow and a broad interpretation of being a fit and proper person. So that would all be taken into account. So no, it doesn't necessarily refer to phase as well. As I've mentioned in the beginning, it is fit and proper within the ambit of the legal profession.
Good evening, Prof. I just wanted to find out, is it possible to serve articles on a part-time basis?
Articles of clerkship, I am not aware of a contract of articles of clerkship that is provided in terms of a part-time basis. Mostly they are entered into full-time with your relevant principal for the relevant prescribed time period. So I'm not aware of any articles of clerkship that's provided on a part-time basis.
Prof,
Thank you.
in relation to that question, I think it's clear that it's made clear that you can't have any other forms of income while completing your articles of clerkship. You're not supposed to be a director of a company or NPO or that kind of sort. So the Act prescribes that when you're doing your articles of clerkship, that should be the only thing that you're focusing on. That's the question that I got.
That's absolutely correct. You're absolutely correct in that regard. Hartnik, there's a question from you.
Good evening, Prof. So prior to our break, I posted a question in the chat, so I would just like clarification there on. There's an old case that I know of where a candidate attorney did the practical vocational training at his father's firm. So I wanted to know if you could provide me with a citation thereof, and in addition, if you could provide me with clarity on it and whether it's allowed, specifically that being that candidate attorney does the practical vocational training at the firm of a family member. How would that work relating to the ethics as well as how the legal practice council will view it? Thank you.
All right. Yes, I saw that in the chat. I'm not aware of the specific judgment, but I'll see if I can have a look and trace it down. But in relevance of working for a specific, a specific attorney's firm, if it's family owned, or if it's a father, an uncle, whatever the case might be, there should not be a problem in relation to admission, obviously, if everything is above board. So if you do your practical, if there is a relevant pupil that has overseen you, whether it's a family or not, a family member or not, that should not be a problem if you completed your articles of clerkship. Obviously, if there's no you should comply with all the requirements of the relevant act, but the fact that a relevant family member is the head of the firm or is also practicing in the firm should not be a problem in relation to being admitted. Obviously, it can become questionable if you have not complied with all the prescripts in terms of actually completing your vocational training, but if it was just a tick box exercise, sort of, in terms of the family providing you with the opportunity, but you're not actually doing the work. That's a different sort of story. But it should not be a problem if you do your practical vocational training with a firm of a relevant family member. And again, so that is why it is so key to study the Act very closely. If it's not excluded by the Act specifically that you're able to, for example, do your vocational training with a firm in which a family member practice, then it is not a requirement for relevant admission, and it would then be allowed. I hope that answers that question.
Yes, guys. Thank you, Prof.
Perfect. Let's just do these 1, 2, 3. I see there's 5 hands. Let's just do them, and then we carry on with the last bit of the lecture for the evening. I'm going to ask Mozoto, and we'll also open again up for questions after we've completed. Mozoto, do you have a question?
Yes, Prof. Can you hear me?
Yes, I can.
Yes, a friend of mine is an attorney, right? And I actually showed him this case when I actually got the case, ne? I asked him that is such case appealable, maybe to the SCA, maybe to the Constitutional Court? And his response was, we in South Africa, anything could happen. So the question that I'm asking is that, is it appealable with success, maybe to the highest court in the land? Is it possible though?
Obviously, you have got a full right to appeal a relevant judgment. So yes, is it possible to appeal the judgment? Yes, it is possible. Would the person be successful in the relevant appeal is another question. The problem with the judgment is, or the problem for Mr. Vacha, should I rather say, is the fact that despite continuously being informed of why his admission application is lacking, what he should be disclosing, he did not do so. So the court provided him with direction. It seems like he had direction from different sources in relation to the fact that his application was lacking what he needed to do to supplement that specific application, which he continuously failed to do so. So it would be very difficult to defend that in terms of going to a higher court, because for being regarded as a fit and proper person, you should be, as I've just said, there's no specific definition, so you should be regarded as an honest person. So it's going to be very difficult for a higher court, having had the direction of the previous court stating that you've got to do this and this and this and that, and he still fails to do so. It seems as if he is trying to hide something, and that is, I think, where it becomes difficult. So yes, absolutely, he's within his full rights to appeal to the High Court and then even to the Constitutional Court, which would be quite difficult, as we'll have a look at the requirements for appealing to or having a case heard before the Constitutional Court. It is a possibility, but I doubt whether he would be successful, because of the very fact that he's had extensive advice from the court itself in relation to his application.
Okay, no, thank you very much.
It's a pleasure. And Molewa, do you have a question, Molewa? Just unmute your mic.
Hello, can you hear me?
I can hear you now.
Sorry, I just saw some colleagues in the group asking to possibly ask questions at the end of the session, so I thought I'd lowered my hand. But what I wanted to say was just emphasis on something you said earlier about including things in your application, even if you feel it's irrelevant. Honestly, in my experience, this is just a little nugget of information. Everything is important. My sister almost didn't get admitted because from when she graduated and 6 months later she attended law school, in that 6 months, my niece had just been born and she did not include that in her application. And we had to be put at the bottom of the roll and come back and declare what she did for that 6 months. So just a future advice for our colleagues, when you're going to make your applications, put in everything. If you spent that 6 months working at ShopRite, because that's what they were asking, like, was she doing vocational work? Was she at home? Was she on vacation? Every little thing that you might feel is irrelevant, rather include it and then have them say, maybe application is filled with irrelevant stuff, but they find the relevant things, rather than for you to say, oh no, well, I had a baby, I don't need to include that. It is important. And another thing is, colleagues are brave out there. That day, there was a lady who had been convicted for forgery twice, and she was still making an application to be admitted as an attorney. It's crazy out there how far people are willing to go to do things. Just include everything and you'll get to see crazy people doing things that you are thinking are impossible. She even had an attorney, like somebody who was representing her, pleading her case. So it's unimaginable the things that go on out there. Include relevant things, even the irrelevant things, just so you don't cry. Okay? That's all I want to say.
No, that's all in order. Yes, it is very important to disclose all information, and a lot of the times you'll sometimes be asked to supplement or put in a supplementary affidavit, as in with the case of Mr. Bacha, and even before so by the relevant law society to please supplement and indicate X, Y, and Z, and then you do so accordingly and exactly according to the prescripts. And again, very, very important, and that's why I say follow the relevant legislation line by line. I'm going to, just want to see exactly how many hands. So we're quickly going to go through the rest and just end by Mochwachai to just allow us to wrap up as well, and then we'll open again for questions. Charley?
Hi, Prof. I just want to ask something. What if I didn't have any discipline hearing against me, but I later complain at the CCMA against an employer? Should that also be mentioned for the application for admission?
As I understand, no. So if there was no judgment made against you, that should not be a question.
Okay.
Similani, can we just maybe ask you to mute your mic? I can hear a mic going in the background. I'm just going to mute that participant. There we go. So no, I don't think that that would be relevant information. It's any judgments or disciplinary hearings that has been made against you that is important to include. Nonkanyiso, your question quickly.
Thank you very much, Prof.
It's a pleasure. Nonkanyiso, unmute your mic. Nonkanyiso. All right, Nombuso. Nombuso, unmute your mic. Okay, then the last one, Motswahai. Yes.
Yes, apologies. I just wanted to find out with regards to admission, if you have an entity that is registered under your name, or if you're a director. Let's say during that period when you serve articles, your company is not generating any revenue. Will that also stand in the way of you getting admitted, even though the company is not maybe active, but it's still registered?
I'm not exactly sure of the exact requirements for the Act, but I think it specifically states that you cannot be the director of any companies. So yes, it might be relevant. Obviously, if you are, even if it's not generating any income, that is something that would need to be disclosed to the court. But just go make sure of the exact prescripts of the Act. But as I understand, you're not able to be a director of the company, of any company, irrespective of whether it's generating income or not, during serving your articles of clerkship. So just go read the prescripts of the Act very carefully. And obviously, as we've just spoken earlier, if all of that relevant information has to be disclosed to the court.
Okay, thanks, Prof.
It's a pleasure. I'm going to move on now. We'll have again towards the end of the lecture, which is not, we're just about to finish off with what I've planned for today. And then we can take questions again towards the end. So yes, those are the requirements for the admissions of attorneys. Very, very important, as I've mentioned, and I cannot stress this enough, is to follow the prescripts of the Act very, very closely in relation to disclosing, following the relevant rules and prescript rule for rule, as I've indicated. And the one website that is quite nice to have a look at it, how it's done. And if you do make use of somebody else's admission papers, do so only as an example, and obviously tailor make it to your own relevant context and situation. And this is just what we all, after law school, quickly realize is what we thought the law is, and practicing the law is not quite as glamorous as we think it might be. All right. The code of conduct is important for a couple of reasons, and we'll be still expressing or going through some of this as we go along in relation to ethics, and we'll touch on it tomorrow as well. Dress in relation to the courts is important, robed in lower and superior courts and be appropriately dressed. Key concepts as well that we will be touching on is the Fidelity Fund, which is to protect members of the public against loss and consequent theft of money or property that's entrusted to attorney in the course of their practice. Tomorrow we're going to spend some time on the Fidelity Fund. And what is important in relation of the structure of the guide, and what we'll be focusing on through tomorrow's lecture and just a section of tonight's as well, is The rules in relation to legal ethics and professional conduct is applicable in your relationship that you have with clients. It's applicable to the relationship that you have with other practitioners, with the court itself, with the community as a whole, with the state and the LPC. And the guide then proceeds to discuss each of these relationships, so your professional relationship with each of these categories. And we'll be spending quite a lot of time, and the most important is your relationship with the client. So if we have a look on page 37 of the guide, is where we start with the treatment of clients and your relationship with the clients. So the Law Society of South Africa has summarized the rights of a client of an attorney, which is quite important to be aware of, and we'll just touch on these points. Obviously, to be professional, honest, and unbiased at all times, to be treated with professional courtesy, respect, and fairness, to privacy and confidentiality, to agree on the type of service you can expect and receive, to clear explanations in terms that you understand. That's very important. To find out from the start of the consultations what you are hoping to achieve and that your expectations are realistic, to know who will be handling your matter, what is the likely success of your matter, and not to do unnecessary work that would lead to unnecessary expensive. That is so important. To an explanation of the cost implications and how the costs are likely to be calculated. This should be done right from the start, and we'll be focusing on some of that tomorrow. To be kept informed of the costs as you go along so that you can work out if a particular course of action is worth following financially. To be kept updated on developments and on the progress of the work as your matter proceeds. To respond to your letters and telephone calls within a reasonable time. That is just in relation to professional conduct in general. To a clear bill which shows the work done and the amounts that's been charged. To be able to complain about your attorney if you believe that they are acting unethical or in an unprofessional manner. Have the attorney's account assessed and taxed if you are of the view that it is too high. And subject to certain conditions, you have the right to cancel your mandate as a client at any stage and consult with another attorney. So these are the rights of a client and your responsibilities to the client as well as a practicing attorney or as a practicing advocate. So please be aware of those. So when we deal with a client, you have to be sure of the client's identity, the client's competence, the authority of holders of power of authority, the client's knowledge of the scope of the instruction, and that also be aware that they are under no obligation to accept an instruction, that you are under no obligation to accept an instruction, and always consider if there is potential conflict of interest, is there any fraud or illegality that's involved here, and are you competent to take that into account? Or to take on the relevant matter. Are you specialized? If you're only specialized in a certain area, and if you're a commercial lawyer and somebody comes to you with a divorce and you're not competent, you refer that relevant client to a relevant competent colleague in that to that extent. In relation to the client, what one should be aware of is the FICA Act. We know from all our experience just having bank accounts that FICA is quite a pain, that there's lots of documents that's needed in terms of FICA, but FICA is also applicable to attorneys as we are counted as accountable institutions. All right, so every client needs to be FICA'd. Effective identification and verification of clients, so keeping of proper records is important. When accepting an instruction, discuss the costs with the client as well as any ethical implications that you might have. Be clear about your mandate. Be precise. A clear and an open-ended mandate can be problematic, and rather have a mandate for every instruction, especially where there's multiple matters and other services, so that you know exactly what you are responsible for, and take clear instructions from your client. Obviously important as well is a power of attorney. So what is a power of attorney? It's a legal document that gives one party the power to act on behalf of another person. It is not a contract. It's a legal expression that the principal can enter into legal agreements and make legally binding decisions for the person. It can be in writing or it can be oral, but as we know as attorneys, it should be preferably in writing and signed by 2 witnesses. You can also get a special power of attorney, which is a very specific mandate, and then a general power of attorney, which gives you extensive powers. Take note of the fact that settlement offers can especially be problematic. You have to obtain written instructions from your client to accept an amount in settlement and explain exactly what a settlement offer entails. Very important in relation to an attorney-client relationship is that you act on instruction, and that you can only act what you are instructed on and not take initiative and do things in your own accord because you think it would be the best for your client. You act on instruction. Important as well is to realize the importance of mediation, and also as of 9 March 2020, parties are required to consider mediation for every new matter that's instituted in a high court. If there's non-compliance with this, it could result in a party receiving an irregular step notice, which could significantly delay the finalization of the matter. And the reason for this is to see if cases cannot be settled or mediated beforehand, before we overburden our courts with over-litigating. So it is very important to consider mediation. The advantages of mediation are discussed on page 53 of your guide. You're welcome to go through that. A mediator is entitled to charge a fee according to a fixed tariff in relation to mediation. Mediation, obviously, very important in relation to family law matters, especially divorces, to avoid retracted legal issues there. To avoid professional negligence, the guide provides a nice checklist on page 55 that you're welcome to work through in that regard. To protect yourself as an attorney, because remember that if you found negligent, you can be held liable for damages or for breach of contract. All right. So I think I am just, before we go into confidentiality and the importance of confidentiality, I think what we'll do for tonight is we'll highlight this as the point in the slide in which terms of which we need to continue. And I think there might be quite a few questions in terms of the chats and questions in relation to what we've covered tonight to answer before we to wrap up. So let me tend to those chats and to the questions as well before we continue where we left off in relation to the client-attorney relationship. But let me just first deal with the hands that we've got. So if anybody's got a question and query, because I see there's quite a lot tonight, let's just deal with those before we wrap up. I'm going to start with the first hand, that is Molewa. Molewa, do you have a question?
Sorry, I thought I lowered my hand.
No problem. Non-Kanyiso. Non-Kanyiso, if you've got a question, you can unmute your mic. All right, let's go on to Farzana. Farzana.
Hi, Prof. Can you hear me?
I can, yes.
I just have a question about the verification of the clients. I just wanted to know, how do you go about doing that? Is there a pro forma FICA document that attorneys can access, or is there somewhere we can go to find out more information about it? How do you verify your client as an attorney acting on your own?
Okay, that's what I just wanted to say. So usually, if you're working in a bigger firm, that would be the legal secretary's job to get all the relevant FICA documents from the client. So obviously, in terms of FICA, I referred to the specific act, and you'll see the act is also referred to in terms of your guide. So FICA specifically prescribes what documents is needed. And if you think about FICA documents, for example, just from the financial, when you go to your bank to be FICA, so basically that's the documents that you would require. For example, your ID document, your proof of home address, etc. So those are the documents that you would need. So obviously, in terms of FICA, if you're acting, if you're a one-man attorney and you run a very small firm, obviously you'll just have to make sure that you comply with the prescripts of the relevant FICA Act, and that those relevant documents are on are those that you can obtain. I'm just about sure that there are lots of FICA checklists that are available. So if you can find a trustworthy FICA checklist, that would be of great assistance. But basically, it's following the prescripts of the FICA Act and then verifying your client and ensuring that those documents are on file. So when obviously you see your client for the first time, and we'll see it through tomorrow's lecture as well. So right from the bat, when you meet your client, there is certain important documentation that you'll have to keep on file. For example, FICA is one of them. Is there going to be the necessary of a power of attorney, a fees agreement, whatever the case might be? So you almost have to, when you are an attorney and you're practicing for yourself especially, and when you don't practice for a bigger firm where there are certain office managers that obviously would see to this, you've got to make sure that you've got a checklist for yourself that says, all right, do I have the following in place? Do I have the relevant FICA documents? And obviously, POPI is also equally important in terms of the prescripts of that. They're equally applicable to attorneys as well, and that's something that I'll mention as well. So have I got all my FICA documents ready? Have I got all my POPI documents ready for my client? What is the fees document that we are going to, the fees agreement that we are going to enter into? So these are all checklists that you as an attorney, when you meet your client for the first time, that you've got to make sure that you've got on record. So obviously, the legislation would be your first port of call in providing you with the relevant prescripts in that regard. I hope that answers your question, Farzana.
Yes, thank you.
Okay. Next question from Ali. It looks like Ali Richard.
Yeah, thanks, Professor. I just want to know from an ethical point of view, is if you've got your law practice running, you got a one-man show, or you got a couple of people working in your firm, but you also want to specialize in forensic investigations where your client comes to you and says, this is the issue. For example, he applied for a tender, there were tender irregularities, and you follow all the prescripts of getting those documentation in terms of the buyer. Can you, as the law firm, would it be a conflict if you perform forensic investigations, either into tender fraud or corruption, or whatever investigations that there is you'll hand the criminal matter over to the police, but you want to use the basis for your investigations for your civil case at the end of the day. Would the Law Society and the PLC allow you to practice as a lawyer and in the same time running a forensic investigation company at the same time? Thanks.
I'm going to speak under correction here, but my feeling is obviously if you use the relevant information to drive a specific case that you're busy with, whatever the case might be, it is not going to be it's not going to be a problem. I also, for example, what is a possibility, for example, if you run a small firm, is that you that you not necessarily will be doing this in your own name, that there will be another employee within the firm that provides this specific service to clients as well. That's also a possibility. But obviously, this is just something as well that needs to be openly disclosed in an open way to your clients first and foremost. I think that's very important to say that these are, if you want to do the forensics investigations, we are also able to offer you this service, but it is separate from the case that we're busy with, or whatever the case might be. So obviously, first and foremost, again, very important to openly disclose this to your practice, and obviously it's dependent on how you're going to work within within your firm. But it's possible to have them sort of operating as two separate instances, but this will have to be disclosed to your clients so that they are not confused in terms of what service is provided and what is part of the service that is provided in relation to the instructions that's provided to the attorney and the services that you will be provided. And in terms of the costs, for example, if somebody at your firm does offer this, that this is a separate fee structure that is entered into with that specific individual, whatever the case might be. So again, in terms of doing something like that, I think it's a possibility, but just again, be very much open and open in terms of exactly what the responsibilities in terms of that would be and how it would influence your legal practice.
Thanks, Prof.
It's a pleasure. Nonya Boliso, you've got a question?
Evening, everyone. Thank you, Prof, for the opportunity.
Mm-hmm.
Yes, it's just an insight. I'm just going to speak under the LPC. You've got 3 points that were raised, and I think maybe I can help with some clarity on that.
Thank you.
Yes, we had a question. It came and someone asked if he or she is a partner or director of a firm, does she have to disclose? And the answer was yes, you have to disclose. And then the question was if the firm is not making any profits. With regards to the LPC, all I know is that the LPC has got what they call a PAC, which is a Professional Affairs Committee. The committee comprises of judges and other legal professionals, advocates and attorneys. They are the committee who decide when it comes to cases like this, more especially with you saying that your company doesn't make any profit. You have to prove to the LPC that your company doesn't make any profit, and you also don't have to be a director of that firm. So they're going to require all those documentations. And the other one was the other who said, what if you're serving under a relative? You must also check that one with the LPC. The committee, also the Professional Affairs Committee, is going to decide, but I'm also going to refer you to Rule 22.1.5, which says a candidate attorney shall not have any pecuniary interest in the practice and service of an attorney. So the case now, the issue now with the PAC, the committee, will be if you are serving under maybe the law firm of your father or your uncle. Doesn't that serve as pecuniary interest with you serving your article with your father. And then lastly, you have to disclose everything with the LPC. You don't have to go and disclose in court, because remember, when you apply for admission with the LPC, you first go to court and get a date for your admission. They give you an enrollment date. Then you take your documents to the LPC. So let's say, for instance, you're waiting to disclose in court that you have previous disciplinary actions, then you're going to get the date to come and uplift your documents at the LPC and go to court, and then that's when you disclose. Then it's going to cause a delay on your application for admission. It was just that. Thank you, Prof.
Thank you. And that's apologies. Yes, so the LPC in a lot of respects would provide you with guidance as well. So sometimes, for instance, they will say, please supplement your papers and include the following information as well. So yes, and this just highlights again, as I've mentioned before, the very importance of reading the rules and the legislation quite closely in relation to your admission application, and especially if you foresee that yours are going to be more complicated. For example, if you are the director of a company, or if there has been a disciplinary proceeding against you, or if you are serving your articles of clerkship with a very close family member. So make sure then that you read the rules and the legislation very closely and make sure that you comply with the letter of the law. Thank you. Adam Sabia, you've got a question?
Yes, good evening, Prof. and colleagues. I've got two questions, but I will try to make it one. Is it possible that after being admitted as an attorney and practicing, be a shareholder or a director of a company, or be employed in a public institution? And then question number two is that during your practice as an attorney, is it allowed to have two offices in different provinces? Thanks a lot, Prof.
Okay, with the first one, and I'm speaking again under correction, but as I take it, after you're admitted, obviously, you'd be able, for example, to be a director of a company, etc. Obviously, one just needs to be open and upfront with things in relation to that, and obviously see to that there's not necessarily a conflict of interest. I think the second part of your question is whether you can have different offices in different provinces. Yes, you could have, obviously, but then you will just have to see the rules and regulations and obviously comply with the prescripts of every specific region in relation to their courts, and in terms of the different court rules, etc., in relation to practicing in different provinces. But obviously, it can be quite expensive if you, but yes. So a lot of the law firms have got different offices in different provinces, but obviously you'll have to comply with the different provincial requirements that's set out for each of the relevant operating councils. Previously, we used to have the different before we had the overarching body of the LPC, we used to have the different provincial law societies. There's an overarching body now, but still every province has got its specific rules and regulations in terms of having a practice in that province. So obviously you'll just have to make sure that you comply with each province's relevant rules and regulations in that regard. Did I answer all of your questions, or maybe did I miss one?
No, you did, Prof, but I have a few follow-up on the first one. So now in the question that my lenient colleague, I think she gave guidance on in terms of now whether you are a director of a company. So is it so in other ways we can maybe, if you one is a director of a company, can maybe what you call it shift the company from his name or her name to someone, and then later stage become the director of a company again.
I understand where you're going. So give up your directorship just while you're doing your articles of clerkship and then resume as soon as you're admitted. That's basically the question. I'm going to speak under the correction here, but I don't have an idea. But it might be a possibility. But I think in terms of getting admitted as as a lawyer is not to complicate life for yourself. So rather not be a director of a company, and rather first get admitted before. But sometimes it happens that you're already a director of a company because of familial responsibilities or whatever the case might be. But as stated again, that just needs to be openly disclosed. To the court and to the LPC as well. Adam, you've got a question?
No, I'm answered. I'm answered, Prof.
Perfect. Adam, you've got a question?
No, I'm Adam, Prof.
Oh, you Adam. All right. Sorry. It seems like the name changed. Thank you, Adam. Jesse Naidu?
Good evening. Hi, good evening, Professor and colleagues. Just a quick statement, two actually, with respect to mediation, Rule 41A that you spoke of a few moments ago. I'm just of the opinion that together with it being a potential irregular step, I've also come in practice with the court perhaps issuing an adverse cost order against a party that was initially opposed to mediation, where the court was of the view that the matter could, of course, be properly ventilated within the ambit of mediation. So that's just also something to take into account that I've literally found in practice as well. The court can be quite upset with parties that may not necessarily embark on the Rule 41A, even though the matter is quite capable of being mediated. And just very quickly, the second thing is, as far as the FICA requirements is concerned, yes, of course, the due diligence is important. But I do note that legal practitioners also have a reporting obligation as far as those thresholds are concerned, just to curtail any potential forum for money laundering and, of course, terrorist financing. I believe it's around 24,999 rand or something of the sort. So that just together links up with the handling of funds and trust account funds, and of course making sure that all checks and balances are in order and due diligence is, of course, adhered to. Thank you.
Yes, that is obviously the purpose of FICA. And yes, again, very important in relation to mediation is yes, that it can land you in hot water if not complied with. So quite important to take note of that, and obviously to advise your clients accordingly before you initiate litigation in one of our higher courts. Charlie, I think it's Maluleke or Maluleka. Charlie, you can unmute your mic. Okay, Deborah. Deborah.
Good evening, Prof. My question is the one around, I see the question of a fit and proper person. There are elements that they have been prescribed, but I'm just asking, in this age of social media, where lots of what goes into our lives, personal or otherwise, gets into the personal, into the social media, whether by us posting or not, what can we say about questioning that? I mean, obviously we post lots of things without you even knowing that in a year's time, when you appear, then one of those elements might arise. So I just want to find out from your perspective what you think about that. Thank you.
Yes, in the beginning I mentioned that professional ethics does not only relate to your work relationship, but also flows over into your in your personal capacity, where you've got to conduct yourself in a proper manner, in a fit and proper manner, and that can and it can it might be it might influence your admission, but also very important in relation to that is post-admission. So it's not just about being admitted as a candidate attorney, but conducting yourself accordingly in relation to after admission. So if you, for example, use social media and you are constantly is seen as being drunk, or you make certain hateful utterances, etc., obviously that could count against you, and somebody might lodge a complaint with the Legal Practice Council, and you might be just struck from the role. And that goes in general in relation to employment, as I take it, it's quite quite an important and a growing facet of labor law, is how we conduct ourselves on social media. And yes, you can lose your employment quite quickly in relation to what you place on social media, and even for what you share on relevant WhatsApp groups, etc. So one has to be extremely careful of your social media presence, what you post and disclose on social media. It might influence your admission as an attorney, but most certainly it also can influence you continuously practicing as an admitted attorney or as an advocate, because it might influence you being seen as being fit and proper person. So, but it's not only restricted to the attorney's profession. This is in general in relation to employment. You have to be extremely careful about social media and what you do post on social media. All right, next question, Mbali Kavu. Mbali, question, unmute your mic. Mbali. All right,
Yes,
next
Prof.
one.
Good evening.
Yes, do you have a question?
Yes, I do.
Mhm.
Is it true that the PLC certificate expires after 3 years?
Is it true that the PLT certificate, I didn't hear that quite completely?
Expires after 3 years.
I'm not exactly sure about the time frame, but I think it does. There is if you've done PLT, it doesn't mean that if you've done it once, it stands forever. If I'm not mistaken, there is a specific time period that is connected to it. Please just read the rules and the legislation to make sure of the exact time frame. But yes. The fact that you do PLT does not mean that it, this course, for example, that it is that it stands, stands forever. If you don't act within a certain prescribed time period, obviously you'll have to redo the course.
Okay, thank you, Prof.
Pleasure, Kwanele. And I think I'm just going to restrict the questions to the last one will be Riabetsu for the evening. Kwanele, you've got a question?
Hi, Prof. I actually do not have a question, but a comment on a previous question by one of the colleagues around social media. I think we have a proper guidance from Lewis's rule that we should avoid any conduct that could damage our reputations as professionals. So whatever that we do, and I think one of the lecturers once said that there's no clear distinction between your personal life and your professional life as a legal professional, because both of those lives actually tend to spill onto each other. So we have a duty and responsibility to ensure that we do not bring ourselves into disrepute, neither the legal profession. So what we do on our private lives, be it social media or whatever, actually has a tendency to start permeating into our professional life. So the advice there would be, do not put up anything on social media that you wouldn't want to be put up on a national paper. That's me.
Thank you so much. No, that's absolutely true. So one needs to be constantly aware of how one conducts oneself within the both public and private sphere. Adam, is it you again? Adam,
No,
last question from you.
No, Prof. I'm fine. I'm fine. I think my hands is lower. I think so.
Okay, there we go. I'll lower it there. Mahlatse?
Good evening, Prof. and fellow colleagues. Prof, I just wanted to ask, unless if this question was answered prior, I wanted to ask in terms of disclosing if you're a director of the company, is it only for those serving their articles or also the PLTs? Because I'm a bit confused about that.
So it would be when you want to get admitted as an attorney. So that would need to be disclosed. So if I'm not mistaken, I can't remember the exact wording of the act. Just make sure you go read it closely. But I think it is while you're serving your vocational training. But obviously, before you start serving your vocational training, and then obviously, if you don't want any problems, you'll need to give up your relevant directorship of a relevant company. But just make sure that you read the act pretty closely in relation to what the requirements is. If it's only during your vocational training or only whilst or even whilst doing your PLT. But remember that you should rather fully disclosed even if you were a director of a company before, and that you then have given that up when you lodge your application for admission.
Okay, thank you so much, Prof.
Riabetsu, and then the last one is going to be for Jacqueline. And then if there's any pressing questions that's in the chats, if you can just please raise them as well. I see there's quite a lot going on in the chat, so I'm going to go through everything. So if there's still a pressing question that you'd like that's in the chat that you'd like me to address, just please raise them now. Riabetsu, you've got a question?
Good evening, everyone, and hi, Prof. At the risk of basically beating a dead horse, I think a lot of emphasis has been placed on being the director of a company, whether or not it's for profit or non-profit. What in the instance if someone incurs an income as a freelancer in their own personal capacity? Is that still something that will have an effect on someone's application for admission?
Just thinking off the top of my head, I think it would. So you're probably referring to a side hustle. So
yeah,
I don't. Yes, I don't think you're allowed any side hustles when you're doing your articles of clerkship. And obviously, if there is anything that you'd need to declare that. But I don't think any side hustles are allowed.
Okay, thank you.
Perfect. Jacqueline, Joshua.
Hi.
Hi there. Jacqueline, just unmute your mic. We're struggling to hear you.
Thank you. Yes, I was just saying I hope you could hear me because we are load shedding at the moment. But I had a question more, I think, curious as to the Legal Practice Council itself. And I know that in 2018 that there was this whole new structural change, and the Legal Practice Council then took over the regulation of all attorneys and all of that. And so my question was around capacity. So we've got the legal practice councils, and we know that the provincial councils are in existence, but are the councils, do they have capacity really to regulate all professional ethics? And I was just curious from that perspective to regulate ethics in all of the provinces, and how successful has that been?
Jacqueline, that's a very good question, and that's a very academic question. One which I think I'm not going to give you my personal opinion on, but yes, that is a very good question, is whether the changes that has been brought about by the current act in relation to the restructuring of the attorney's profession, whether that has been a success or not. I know that the legislation has been critiqued quite a lot because it is not very well drafted. It has been seen as quite a cut and paste job between the previous act with not enough guidance in relation to the current status. So there's been loads of teething problems with the new act in relation to its structure and even with the Legal Practice Council. So yes, a lot of critique in that regard. I'm not necessarily going to express myself on that. Yeah, but yes, it's definitely something that should be taken account of. It is very concerning for the profession to know that there might be several challenges, but the challenges is not only in relation to capacity. The challenges is also in relation to the way in which the act is drafted. And sort of the loopholes that is there, and not only loopholes, the fact that a lot of the issues are not properly addressed in terms of the act. So yes, it's very complicated traversing the legal practice as it stands, because there is still so much uncertainty. Possibly there might be regulations or that's issued in future that provides some clarity and expands on some areas where there is shortfalls, but we'll just have to wait and see. And capacity, it most certainly is a problem, but that is something that we will have to deal with in the future. And as I've said, hopefully we'll be getting some guidance in some way or some form. Cora, you've got a question?
Yes, thank you for the opportunity, Professor. If I take instructions on from other attorneys, for example, to do a bill of cost on taxation or to oppose a bill of cost, do I need to FICO the law firm? Because my attitude is that cost belong to the client and not the law firm. So I cannot contact their client. My view is that they've already FICO'd their client. They've already made sure that everything is in order, have a copy of the ID, etc. And I have a problem at the law firm where I am at the moment, that the bookkeeper wants to FICO all the law firms where we are dealing with. For example, if we get the instruction to oppose or to do a bill of cost and take it to court. What is your view on it?
Yes, that's quite a technical question. I'm not exactly, I'm also again speaking under correction. What my gut feel says is that as well, that if it is the original firm's responsibility or the instructing firm's responsibility to FICO the relevant clients, but obviously if it is something that the bookkeeper requests, then obviously you should be able to request it from the relevant instructing firm. But again, I'm speaking under correction. It is quite a technical question. So unfortunately, I don't have a direct or precise answer. If anybody else has got the information, they're more than welcome to share it with us in the chats. But yes, my feeling is that obviously that client would have been FICO'd, but in relation to being FICO'd, if that documentation is requested, obviously, if the client has been FICO'd, that information should be readily available and should be provided to the relevant accounting firm when and if requested. One more question, Veronica. Veronica, unmute your mic. All right, guys, I'm not going to go through all the chats bit by bit. Is there any pressing questions that is from the chats that I have not addressed during the course of the evening?
Prof, someone asked earlier on, and I'm sorry if we're going off topic, but if you do your articles, and the example they used in the chat was if you do your articles at a firm in the Eastern Cape, could you get admitted at the High Court in Johannesburg, or would it pose a jurisdictional challenge?
Yo, good question. I'm not sure, but I think it would depend on the relevant prescripts of the relevant province. That you comply with the relevant prescripts that's set out in the relevant province. It also depends on where are you planning to practice. So whether you've completed your articles of clerkship and your articles of clerkship in Gauteng, and then you're admitted in whether it's it doesn't really matter as long as you comply with the relevant prescripts of the relevant province that you are planning to practice on. So wherever you do your articles of clerkship is not going to be a problem. But when you do your admissions, obviously, you'll have to inquire from that relevant council, provincial council, what is the requirements of being admitted in that province, and then follow those relevant prescripts. So it doesn't matter if I go and do my articles in Gauteng, and I then decide I want to come and practice in the Cape, but I've got to make sure in relation to my admission that I comply with the relevant prescripts of what the relevant provincial prescripts that is stated there. And again, to get guidance from the Act and the relevant guidelines, and then from the LPC itself, in cases where you foresee that your admission might be challenging.
Prof, sorry, Prof, can I just ask one more thing before we log off?
Yes.
I don't know if this is a question for you or for the administration of Zukiswa. On the system, under tests and quizzes, they've loaded the main test for the subject. But I've also noticed they've loaded which they call assignments for this subject and other subjects. Now, my understanding is that we do the tests and quizzes, the multiple choice, which is 1 hour, 100 marks, and you must get 50% there.
Mm-hmm.
Now, when it comes to the assignments that was loaded onto the system, and I see the time is also 1 hour. So must we do that assignments as well within the hour, and will that be marked, and will that be counted as a mark as well? Thanks.
I don't have an idea. Is there anybody that's got an answer for Mr. Richards in relation to the question? I think it would be best to direct your inquiry to Zukiswa, and in relation to how the assessments are going to work for the subject exactly, so that you make sure that you comply with all of them. So I think just direct that query to Zukiswa. Sasha de Beer, do you have a question quickly?
Good evening, Professor, and all my learned colleagues. Professor, yes, I just quickly, for ethical purposes, I would like to find out something. So, for example, if you take on a case for a client, just an example now, recently I had a case where by one of my clients, he put the guy out with an eviction order, and then the guy came back and he broke the window, and then he went back into the place, and then he just sat there. But then we saw that this guy is not psychologically fine. So obviously I want to know, would it be unethical if you then assist the guy with getting, even if it's not your client, and you act against him, to get him like the necessary psychological help? I mean, for me, I want to know where's the fine line between humanity and having your emotions, and then obviously being ethical.
Yes. No, it's a relevant question, but my feeling is that one has to be careful because obviously you've acted against this person. So my best advice in such a situation would be to just provide advice and say, you could and refer the person. So to obtain the relevant help, I suggest you contact the following person or the following social worker or the following NGO that might be able to provide you with assistance, provide an email address, a telephone number, or but that is, I think, where your responsibility ends and where sort of, so you can provide relevant information, but further than that, I would not get involved necessarily. So there's not anything against providing relevant information to the person of where they're able to obtain help, but that's where you should draw that line.
Okay, so it won't be like a conflict of interest if you try and assist them with, being admitted to a psychiatric ward or something like that.
I would not necessarily assist with being admitted to the psychiatric ward. I would just refer the person to a place where where they would be able to obtain help, and that is where I would draw the line. Not getting any further involved with that relevant individual, but just saying, obviously you're in need of help. This is where you're able to obtain help should you need it, and then and then step back.
Okay. Oh, thank you so much for your assistance. Thank you, Professor.
No problem. Quintus?
Prof, hi. Going back to the course outline, on page 11 of our manual that we have, they talk about Uberrima feeders. In the case of Law Society of Cape of Good Hope versus Holmes. When I read this, I was taken back to my insurance. So I did insurance as a final year elective. And the case of Mutual and Federal v. Oudtshoorn Municipality, there the appellate division held that it was time to jettison the notion of a Uberrima feeders because there isn't a degree of feeders. There's just one standard. Now, my question is, that was in the confines of insurance law. Would it not find application also in this regard?
I doubt, because it would depend on the relevant factual scenario, and I don't think it is relevant in relation to the context that it's referred to here. So most probably not. So just remember that in terms of the applicability of precedent or any case law is the fact that you have to look at the relevant context and relevant factual scenario, and does that fit? So in the reference of, I think, what is referred to here, it is specifically in relation to being fit and proper. I'm just referring to the relevant page where that's referred to, and it should be viewed within that context. Yes, it's to refer to what is a fit and proper person, and not within necessarily the context of insurance law here per se. So yes, it should be seen within that context.
Okay, thank you.
Shantae, Rubain.
Ma'am, sorry to bother you and interrupt, but if we're not going to cover any more work, can I log off for the evening?
Yes, please do so. And that's
Thank you
just
so
what I
much.
wanted to say. Is there any other relevant questions pertaining to the content of the work that we're
Prof,
going to
my
cover?
question isn't with the content. I just wanted to echo one of the questions in the chat, and that was whether an e-copy of the guide will be loaded onto the e-leader portal by any chance.
You'll have to discuss that with your administrator, with the Zukiswa. I'm not too sure. I'm just referring to the guide here because it's just easier to pinpoint you to specific. So I do have an electronic copy myself, but that is just to facilitate the teaching of the module. So I'm not sure if electronic copies will be made available to students.
They're already available, Prof.
They are available.
There we go. And I think they are available they're available on the e-leader platform. Am I right?
That's correct, Prof.
Sorry,
Yes.
guys. Can you just guide me as to where to find it on the e-leader platform then?
If you select the LSSA tab,
Yeah.
once you've logged in, and you go down to resources, you
Okay,
scroll
perfect.
down into PLE, you'll see
Yep.
that there's a copy. So all of the tabs have a copy of the documents you
great.
received
I
in your
found it.
box electronically.
Much appreciated. Thanks, guys.
Sure.
Okay. And then just a short note for tomorrow. I'm absolutely fine to talk until 2030, but maybe if you guys would like to finish a bit early in the evening, just to keep your questions specifically pertaining to the content of the work, and then we'll be able to finish a bit earlier. So yes, for tomorrow, let's just stick to questions particularly pertaining to the content of the work, and then we might just finish a bit earlier, and to enable people to spend some time, either studying or with their families. I know that I've got a lot of respect for every student that's doing this in the evenings, and I know that it is quite exhausting to do so. Last question or comment, Huiti R.
Prof.
Yes.
Can you hear me?
I can.
Yes, just to allude on what you have just mentioned, can we jot down the questions as we go on with the work, then ask the questions later on when you're about to close? Because right now we didn't do much work. It was just about questions and answers.
Let's do that. So what I suggest for tomorrow evening is I'll continue with the work, and then we'll finish with the content, and then we've got a stretch where we'll answer questions and queries. Will that be in order with everybody?
Yes, please, Prof.
Yes, Prof.
Yes,
All right.
please.
Yes,
So no questions in between, no raising of hands, no unmuting of mics. So we'll do the content, we'll do questions. Is that fine with everybody?
Yes, Prof.
Perfect. That would be
Yes,
awesome.
Prof.
Okay, sharp. So that's what we'll do tomorrow.
Yes.
Is get through the content, questions. All right. Have a very good evening, everybody. I'll see you tomorrow, and we will then proceed with the lecture with the content and thereafter questions.
Thanks, Prof.
Bye.
Good evening.
Bye-bye, guys.
Good
Good evening, everybody.
Great
Thanks.
lecture.
Good night.
Thank you. Bye, guys. See you tomorrow.
Bye.
Bye.
Bye.